Yep, so we're live now.
Let me know when to start.
I would suggest waiting for a couple of minutes until everyone joins us, and then we will start.
Sounds good. Thank you.
Okay. Okay, I see people already joining us, so I guess we can start. Let's start by presenting our ScaleUP webinars, which are aimed at educating Armenian startup ecosystem with practical knowledge from local and international experts. So our today's guest is Hayk Mamajanyan, who is corporate attorney specializing in startups, venture capital, M&A transactions, and the principal at the HVM Law Corporation. Haykjan, thank you for being with us today, and we are very excited about the presentation. I guess we will cover very interesting and practical information today. So I will give the floor to you. Please tell us more about your background, and then we can proceed with our presentation.
Perfect. Thank you so much. Hi, everyone. Thank you for joining us. Today's presentation is about early stage startups, introduction to the US legal system. Let me maybe first share my screen so everyone can see the presentation. Can you see it? Awesome. So today we're going to cover the most basic legal requirements that each startup that is based in the United States must comply with. And let me start with a disclaimer, and then I'll talk about myself, about the firm, and then we'll discuss the topic. So first, disclaimer, and let me read this because this is important. This material is for informational purposes only. It should not be considered legal, financial, or other professional advice. You should consult with an attorney or other appropriate professional to determine what may be best for your individual needs. What this means is that we're going to discuss a lot of hypotheticals. We're going to discuss some legal solutions, some problems, how we solve them. But when you have your own specific case, please reach out to an attorney or to another professional to discuss those issues based on the actual facts and find customized solutions. And also, this presentation is going to assume that we're discussing Delaware C Corporation. Why Delaware C Corporation? Because that's the standard in the VC market. And this doesn't mean that a lot of these considerations would not apply to California corporations or New York corporations. They would, for the most part, but still the presentation will focus on a Delaware C Corporation. So now a few words about ourselves. HVM Law Firm, we're legal advisors to entrepreneurs, founders, investors, and VC firms. And we work with both investors and startups, and it helps us to, we've been on both sides of the table and negotiate deals from both sides. And it helps us to see the perspective from both sides and help parties to come to a solution to focus on the problem and close the deals. And also, we're trying to be strategic partners for our clients, meaning that we're not just helping with their legal needs, we're also trying to help them with some advisory services, such as making introductions to accountants, investment bankers, VC firms, angel groups, as well as helping them with their other needs. And as was mentioned, what we do, we focus on VC deals, we focus on M&A deals, we focus on corporate structuring, but we also have attorneys that help us with taxation, business immigration, litigation, and we also have IP specialists that we work with, intellectual property specialists. And two exciting news, and I don't think anyone knows this yet, but first, we're working on setting up a VC firm that would focus on Armenian startups, and we would invest in early stage startups from seed stage to Series B. And it's not going to be a huge fund, up to $20 million, but we'll focus on Armenian startups and hoping to start making first investments as early as Q1 of 2022. So that's number one. And number two, HVM Law Firm is also going to open an office in Yerevan, Armenia. And that's probably going to happen around the same time, sometime later this year or early next year. We already have two excellent associates, one licensed in Armenia, another one licensed in California. Both live in Yerevan. And we're going to add more people, and then we'll make an official announcement very soon. So let's start discussing the topic. And first, I want to mention that when I refer to US legal system, we're not going to discuss precedents or US Constitution today. We're going to focus on how to solve problems, how to address some issues that every single early stage startup faces. And I want to emphasize the fact that even though we're going to focus on US legal system, the challenges are the same around the world, and those are mostly economic business challenges. And then the legal systems of different countries try to address those problems in similar but also different ways. And I want to list a few issues that any startup founder or founders, co-founders think about before opening a startup. And they're not legal questions. Those are economic questions, such as, how to allocate the risk, among the founders, how to address some asymmetry of information issues within the investor group and the founders themselves, or how to align the incentives, right, of the co-founders and the employees and the rest of the team. And, opening any business, there are a few things that everyone thinks about, and number one is liability, right? Am I going to be personally liable for the debts of the business. Especially for startups, it's a risky venture, and you have to make sure that if something goes wrong, you're not going to have to pay up using your own personal assets, such as your house, your car, your personal savings. You want to make sure that those are protected. Then also, you want to make sure that the assets of the business are protected too. And at the early stage, the assets are mostly the intellectual property of the startup. That could be some patent earlier stage, that could be trademark, that could be copyrights, that could be some other ideas, some other confidential information, that could be trade secrets. And also you want to make sure that the understandings among the founders are clear to everyone. That's another consideration. Of course, tax considerations. Are you going to focus on capital appreciation? Are you going to focus on making money, making profits, making revenues? And typically for startups, tech startups, the goal is the capital appreciation, increase the value of the company, and then sell it to a strategic buyer or to a private equity firm or go public. So that's a consideration as well. Also, how are we going to attract capital? Again, a business issue. How are we going to make the company, the business, attractive for investors, angels, family and friends, more institutional investors down the road? Also, the same goes towards attracting talent. You want to make sure you're able to recruit the best people in your ecosystem to work with you to make your startup a success. Also, you want to make sure that you document the relationship with your vendors and services providers. And last but not least, growth and exit planning. And believe it or not, when I speak with clients or prospective clients, this is one of the first things, along with taxation, that I want to discuss, because I want to understand what is the goal and what's the plan to grow and what's the plan to exit the company down the road. A lot of people don't have the answer when they start the business, but still those are good things to think about when you're starting a business, again, for tax, investment, and other reasons. So those are the common challenges that everyone faces in every single country when they come up with their startup. And next, we can discuss very specific solutions that US legal system, or namely Delaware, provides for some of these common challenges. So number one, the first step when you enter the legal world is incorporating a legal entity. And there are a few things you can do here. The main entity types are limited liability company, or an LLC. And in America, you can also go with a corporation. And for corporations, we have two different treatments, tax treatments for corporations: S corporations and C corporations. And the short answer to the question of what entity type I should choose for my startup is that you should go with the Delaware C corporation. And why, we'll discuss next. So number one, of course, you want to provide limited liability to the owners of the business, to yourself and your co-founders. And C corporations do provide limited liability and asset protection, meaning that you don't have to use your own personal assets, your savings, your house, to pay for the debts of the corporation. Also, the corporate assets will be protected too, as long as it's clear that those assets belong to the company. It's documented somewhere that the assets belong to the company. But the question is that the LLCs and S Corps do provide the same limited liability and asset protection protections. So even though this is crucial, but this is not the answer why go with the C corporation, because the other entity types also provide the same protection. So next, we also want to make sure that whatever entity we choose, it's investor friendly. And this is where C corporations really stand out as one of the best entity types for investors, because as we discussed already, when an investor, and even founders, right, when they create a startup, they don't really focus too much on making money in terms of making revenues and then making profits and paying dividends. Why? Because they know that for the first 5 to 7 years, they're going to have to reinvest every single penny they make back into the company in R&D and marketing and business development and product development. And the main goal is to scale up the business and increase the valuation, and then see if you can sell it down the road or go public and continue with your founding team. And investors want the same thing. They're not interested in dividends. Most of them, at least startup investors, professional investors, VC firms, they want to see growth in the company's value, and then they want to see a successful exit. And C corporation provides the best tax benefits for value appreciation. And also there are a couple other reasons why LLCs and S corps cannot be the best for investors. For example, S corporations, even though they have amazing tax benefits for certain businesses, they're not viable for startups because, for example, you can't have shareholders that are not US residents, right? So if someone is an Armenian resident or lives in a different country, they cannot qualify for an S corp treatment. You can't have more than 100 shareholders. Not a huge concern because I don't think at an early stage you want to have more than 5 shareholders, maybe then 10 investors, 20 investors. But also legal entities, LLCs, corporations cannot be shareholders in S corporations. So again, a huge obstacle because VC firms are legal entities. Some of the strategic investors are legal entities. So that's another reason why you can't go with an S corporation. And the last reason would be that you cannot issue preferred stock in S corporations. And that's, again, a huge obstacle because all institutional investors, VC funds, private equity funds, they look for preferred stock. They want some economic incentives and preferences over common stockholders, and you cannot do that in an S corporation. So now we're left with C Corp and an LLC. And why not an LLC? Because it's hard to reinvest your capital back in LLCs. Plus, you have to issue K-1s to your investors on an annual basis. Again, a headache for you and as well as your investors. So another reason not to go with an LLC and always start as a C corporation for limited liability and now also investor purposes. But those are not the only considerations. Taxation, huge, right? And for taxation, I don't know how many of you guys know about this, but in the States, we have qualified small business tax exemption. And the meaning of the exemption, and that's, I think, under section 1202 of the Internal Revenue Code. And the purpose of this code section, this exemption, is to incentivize founders as well as investors to start and then invest in startups. And the gist of it is that if you invest in a startup at an early stage and you hold your investment for 5 years, then you're exempt from up to $10 million in sales proceeds from capital gain taxation. Example, and one of my clients recently, earlier this year, he did have a huge exit, and we did take advantage of this exemption. And what we did, we created a legal opinion for him, and we laid out all the facts and all the necessary considerations in the legal opinion, showing why and how his proceeds qualified for this huge exemption. But there's some certain things that you have to qualify for before you get the exemption. And at the shareholder level, it has to be an individual or an LLC. It cannot be a corporation. Corporations will not qualify for this exemption. Also, the shareholder has to buy the shares from the company directly, not from a third party. So that's another requirement. But there are also a number of requirements for corporations themselves. And number one is that it has to be a C corporation. So again, remember that if you want to take advantage and qualify for 1202 exemption for up to $10 million of your sale proceeds, then you have to be a C corporation. Number two, you have to be an active business, meaning that you cannot have more than 20% of your assets in securities or in real estate. And recently, a few days ago, one of my clients called me and they told me that they moved to a new office, and now the office is far from the houses of the executives. And what they want to do, they want to buy houses for executives close to the office, so they don't have to commute for too long on a daily basis. And the analysis was that that's fine as long as the value of the real estate, the real property that they're going to buy, does not exceed 10% of the corporation's assets. Why? Because we don't want to disqualify from this huge tax benefits. And the conclusion was that now we have to do an evaluation of the assets of the company and then see if the value of the house that they want to buy is bigger than 10% of the value of the assets. Then also, the total assets of the company that issues stock cannot be more than $50 million. But this is not a huge concern at an early stage company because rarely any early stage startup has assets that are valued for more than $50 million. And also, there cannot be any redemptions or repurchases of shares in a C corporation, meaning that you cannot provide an exit to your shareholders because the IRS wants the shareholders and investors to take the full risk of investing in an early stage startup. But that being said, it's okay to do redemptions or repurchases of stock if a co-founder leaves. I had a very recent transaction where a co-founder left the company and we drafted the repurchase agreement and release agreement. And we also added language that this is not going to disqualify the company or the stakeholders from relying on the QSBS exemption because the law allows us to buy back the shares of a departing co-founder. So this is taxation, huge. Again, one of the biggest reasons why we go with the C corporation. And this is, by the way, win-win for both founders and investors, as well as employees and advisors of the company. Anyone who holds stock that got it from the company at an early stage can benefit from this. I mentioned the 5-year holding period, and that's what qualifies you also for getting the benefits. But if you sell in 3 years or 4 years, you can still roll over the entire amount of the proceeds into a replacement QSBS, and the replacement C corporation investment within 60 days. And that means that, again, you won't have to pay any taxes. Again, you can't just take the money and buy a house or buy a car. But if you exit earlier than 5 years after 6 months, then you can, within 60 days, roll over your proceeds into a replacement qualified small business tax investment without paying any taxes. Next, equity incentives. As we discussed, the purpose of having the right legal entity is not just to provide tax benefits and to attract investors, it's also to be able to attract talent, people that you want to work with, people that are going to help you to scale up your startup. And for equity incentive purposes, again, C corporations are the best vehicles. Why? Because unlike LLCs, the IRS does have very clear guidelines about tax benefits and tax treatments of equity incentive tools, such as restricted stock, such as stock options in C corporations. That being said, this doesn't mean that there are no equity incentive instruments in LLCs. In LLCs, you can do profits interest, you can do incentive units, and we're working on an incentive unit for one of our clients. And essentially, the client is growing. Now they have 25 million in revenue, and now they're thinking about incentivizing their employees and advisors even further to reach larger milestones, and that's why they're issuing incentive units to their employees. But this is not a tech startup, so they can do that. But for tech startups, you go with the C Corp, and because of the tax treatment, very clear guidelines for tax treatments, you almost always want to issue restricted stock at an early stage or stock options at a little later stage. And last, Delaware C Corporation. Why? Because Delaware C Corporations the Delaware code does provide the best, one of the best benefits in the country for founders and management. It does protect the management. It has a very strong business judgment rule exemption. It also has very good indemnification provisions for directors and officers. So those are huge considerations too. You do want to make sure when you found an entity that you're protected, especially as you grow, as you scale up, because once you have a few investors, once you have a few advisors, a few employees as stakeholders, then you want to make sure that you're protected by the law and you can make decisions based on your business judgment without fearing for any lawsuit or liability down the road. So those are the main considerations why a C Corp rather than anything else. And now we can discuss the actual incorporation process. Okay, now we decided we want a C Corporation for all the reasons we discussed. Next, what are the practical steps that we need to take in order to have the corporation active, up and running? So first, you have to file a certificate of incorporation in Delaware, and articles of incorporation if you decide to file in California. So certificate of incorporation is the main constitutional document that incorporates the corporation. And it has a lot of formalities in it, but a few very important practical things. Number one, the certificate of incorporation authorizes the maximum number of shares that the company can issue to its stakeholders, investors, stockholders, investors, advisors, employees, everyone that you want to incentivize or you want to give equity in exchange for their cash investments. And what I do typically, I go with larger numbers, 100 million shares of common stock, 100 million shares of preferred stock. And the reason being is that I want to give my clients a bigger number of shares, units to work with so they can allocate it to a bigger number of employees and advisors. We don't know if startups are going to be successful or not necessarily when we incorporate them, but the assumption is always that they will become successful. So we are preparing them for success. And, again, from my own experience, I always say this, that I myself have shares and some of my client startups, and it's always nicer to get 500,000 shares versus 50,000 shares, even though economically it represents the same value. If, let's say, the company had 10 million shares versus 100 million shares, 50,000 will be the same as 500,000, but still getting 500,000 for whatever reason feels better. And board powers, we also want to make sure that we delegate as many stockholder powers, shareholder powers to the board. And the main one would be for the board to be able to issue preferred stock with an easy, short, concise board consent versus shareholders having to do that and then going to the Delaware state to try to amend the certificate of incorporation. Another thing you can do with number of shares, you can create different classes of common stock, Class A and Class B. You can give yourself extra voting rights. You can give yourself 10 votes per share, and then that would be Class A shares for founders. And then you can set aside 20% of the common stock pool. Let's say 100 million shares, you would set aside 20 million shares, and you would call these shares Class B shares, and then you would these shares would have the same economic rights as your shares, but then they would vote one vote per share versus 10 votes per share. And that would protect you not from economic dilution, but from management or decision-making dilution. So even though you issue stock and you give rights to your investors and to your employees, and they share the economic benefits of the company on the same footing with you, but when it comes to decision-making, as stockholders, you would have 10 times more votes than they would. So this is the certificate of incorporation. And next, you have to have a registered agent in Delaware. And this is a requirement in almost every state. When you open an entity in any state, you have to pay a local corporation, a service agent, registered agent to act as your registered agent in that state. We handle this too. This is not a big deal, it's a formality. Next, you should also obtain an EIN number, federal tax ID number for your business. This is a very easy procedure process, and we do this ourselves. It takes us maybe 10 minutes to do this, but first we have to incorporate the company and then obtain the EIN. Then if you are doing business actively in the state of California, let's say, right? Because this is the most relevant state for any startup, then you also have to register your Delaware entity in California. So now you have your Delaware entity, you have the certificate of incorporation, but now because you do active business in California, California requires you to also register your entity in California, and we do that too. And then on top of that, you also have to file a statement of information with California. And then sometimes you need business licenses, depending on what business you're in. And there could be other filing requirements based on the industry you're in and the state that you're in. So this is how we incorporate, and we're incorporated now. We have the EIN, we're ready to go. We're trying to open a bank account, but now we have to have some governance documents to even be able to open a bank account. The certificate of incorporation and the EIN by itself are not enough to be able to open a bank account for the most part. So the first document would be incorporator's consent. And what this does, the incorporator, which is me or some other attorney or some other online service that did this for you, they resign and then they appoint board members. And board members would be typically the co-founders, 2, 3, 4 people, maybe even 1. And then when they appoint the board members, the incorporator resigns. But before resigning, in addition to appointing the board members, the incorporator also approves the bylaws of the company. So you have to have the bylaws by then, and you also have to have the names of the board members before the incorporator can resign. And that's when the founders take charge and they start making decisions. And that's why we need bylaws, because we want to make sure that all parties know what their role is, what they can do, what they cannot do, how they can do the things that they can do. A lot of procedures, a lot of processes and trade-offs. Who are the stockholders? What are the rights they have? Who are the board members? What are the rights they have? And what are the officer positions? What are the rights and obligations that officers have? And once you have the bylaws, then of course you have to have a board consent or board resolution. And what the board resolution does, it essentially approves all these transactions. It issues shares to co-founders. So now we have 100 million shares authorized. Now we can issue up to 100 million shares. So now the board resolution, the consent itself, is going to issue shares to co-founders. Let's say we have 2 co-founders and they want 40 million shares each. And then 20 million is being set aside for future hires, employees, advisors, board members. So the board resolution will have to clearly state the names of 2 co-founders and the number of shares that they receive each. And then also the board consent would appoint the officers, the CEO or the president, the CFO or the treasurer, and the secretary. Why these 3 positions? Because you can think, oh, how about technical officers? How about operation officers? How about marketing officers? Because those are product development officers, because those are more important for a startup. The reason for these 3 positions is that simply they're mandated by law. Every single corporation has to have these 3 officers: a president, a treasurer, and a secretary. All 3 positions can be held by the same person or by different people, doesn't matter, but you have to have, again, clear names and positions in a board consent. There are a few other things that you need to have in a board consent. For example, a client calls me yesterday and he tells me, we're adding an advisor. I know we have to sign IP assignment. I know we have to sign a services agreement or a consultant agreement. I know we have to sign stock purchase agreement, but do we need a board consent? And the answer is absolutely yes. Why? Because unless you have a board consent issuing stock to a person, there is no stock, there is no ownership of stock. There is a contractual obligation by the company to issue stock to that person, but there is no stock per se unless and until the board formally makes a decision in a board consent in a written form to issue stock. And this goes even further because, again, recently I was reviewing this agreement. There was an issue between some parties, my client and their services provider. And the issue was that my client wanted to terminate the services relationship. And then in the agreement, we had this provision that the services provider was supposed to receive a certain number of shares of the company. And because the client wanted to terminate the relationship, they didn't want to issue stock. They didn't want to give stock to the services provider. And what happened was that there was a section in the actual agreement itself saying that even though the CEO signed this agreement promising that the services provider will receive shares of the company, it is subject to the board consent. It is subject to board's approval. So the agreement itself clearly stated that even though the contract says that you will get shares, it will not become effective until and unless the board itself decides to honor this contract and issue shares to the services provider. So be careful with those sections as well to make sure that you know the implications of the contract you're signing. Then next, you want to have a stock purchase agreement, and you would ask why, because everyone knows I'm the co-founder. I have board resolution issuing the stock. Why would I have stock purchase agreement? You do want to have a stock purchase agreement for a number of reasons. Number one, taxation. Qualified small business stock. You want to show to the IRS that you followed all the formalities of issuing stock. So it's not just the board consent. You also want to have a stock certificate. You also want to have a stock purchase agreement showing that the transaction between your company and yourself was at arm's length, meaning that it's a real transaction, it's documented, and you can prove to the IRS the date of the issuance of shares and the date of consideration, which is something that you have to give to the company in exchange for the stock. You want to show that there was, first, the board resolution, second, there is a stock certificate evidencing the shares, and also there was a consideration documented, an exchange of some value between you and the company. The company gives you shares, you give company cash, or you promise to provide services. So that's why we need to have a stock purchase agreement. Another huge reason to have a stock purchase agreement is vesting schedules. And vesting schedules become necessary when you get shares in exchange for your services to the company, meaning that unlike cash, that you can give cash to someone and get the shares within minutes or within seconds these days, it's not the same with services. When you get 40 million shares of your company, you can't provide all the services within a minute or within an hour, or even within a year. You're going to have to continue providing services for years to earn the shares, and that's why it's called sweat equity. You earn the equity by sweating, by working for the company. And clearly, now you need to have a vesting schedule showing how long you have to work for the company to vest the entire 100% of your shares, and what are the repurchase provisions of the vesting schedule of the restricted stock purchase agreement, meaning that what happens if you leave in 2 years, right? Let's say you have a vesting set schedule of 4 years, and then you or a co-founder departs in 2 years, then you want to know how many of the shares the departing co-founder can keep, and how many of them are going to become the corporation's property. And this is why you have to have repurchase provisions in a stock purchase agreement. And this sort of stock is called restricted stock because it's restricted by the companies, the startups, right to repurchase your shares when you decide to leave the company or when you're terminated, because sometimes you can be terminated even as a co-founder. So if anything happens and you part ways with the company, with the startup, then we have to know the certain rules, the exact rules of how to treat the vested portion of the shares and then also unvested portion of the shares. And also equity incentive plan. And why do you need to have an equity incentive plan? Again, for hiring and recruiting reasons. You want to make sure you have one centralized document that lays out all the rules that apply to restricted stock, that apply to issuance of stock options, such as incentive stock options that you can issue to your employees, and also non-qualified stock options that you can issue to executives. So again, equity incentive plan, very important because it does lay out all the different rights and obligations of both parties, and also the processes that the company and the stockholders or option holders have to follow in order to get the benefits of the equity or stock option awards. So next, so these were corporate considerations. You have to have at least these things in place. After you incorporate, then you have the governance packet, initial governance documents addressing all these different business and economic issues. So next, IP considerations and disclosure. I'm not an IP attorney, but I do want to address this as well, because at an early stage, the only thing, or at least the crown jewel of any startup, is its intellectual property. That could be a trademark, a very interesting trademark. That could be your patent. That could be a copyright or trade secret. And you do want to make sure that that's protected. But before we get to patents, trademarks, copyrights, and trade secrets, let's discuss inventions assignment agreements. This is one of the most important agreements for any startups. And the reason for this is twofold, right? To make sure that if someone works for you, including the co-founders, and they create some value, the value stays with the company. You want to make sure, this is the asset protection aspect of corporations. You want to make sure that there is one unit, which is the C corporation itself, and there are people that work for the C corporations, contractors, advisors, employees, co-founders, and everything that these people create as a result of the work that they do for the company belongs to the company, not to these people individually. And of course, this is the asset protection, but also this is super important for investors as well. Because when investors invest, of course, they invest in the team, right? They like the team, the co-founders, they're happy, they trust them, they believe in their potential. But legally speaking, they invest in the entity rather than in the team. So when they invest in the entity, they do want to make sure that the intellectual property that all these people create belongs to the entity. And as an attorney, when I do due diligence, this is one of the most important things, that you want to make sure that the startup has inventions assignment agreements signed with everyone, co-founders, advisors, employees, anyone that they work with, and needs to have inventions assignment agreements signed with. So this is the most important thing, but also there are patents, trademarks, and copyrights, as well as trade secrets that you have to either register, or at least to think about, for example, for patents, right? That's a process, design, or invention that you want to protect. And the way you protect it, you have to disclose the details of your invention to tell the world that, look, this is what I invented and this belongs to me. And you do this with the patent office in the United States. And the same with trademarks. You do want to make sure that when you pick a good name, pick a good logo, or a combination of a mark and a word, you have the full protection of the law. And the way you do that is to file a trademark with a patent and trademark office in the United States. And trademarks are important too for two reasons, because number one, you don't want to use someone else's trademark, right? You want to make sure that no one else has been previously using the same name or logo, or something that would be misleading or confusing for the public, because you don't want to create a great startup and then all of a sudden you realize someone else is using it, and now you have to leave the name and then even potentially pay damages to the other party who owns the trademark. But also you want to make sure that no one else can use your trademark. So number one, you're not using anyone else's trademark. You don't have to pay damages for using their trademark. And number two, you are the owner of the trademark and no one else can use it after the registration of the trademark. Then copyrights and trade secrets. We don't do too many of these, but copyrights, they relate to any creative works such as books and other things like that. And also trade secrets, those are any confidential information that has very huge value for the company, such as recipes, right, for restaurants and chains. And next, some other considerations I wanted to go through really quickly, because those are not the main ones, but those are sometimes are important as well. Terms of use and privacy policy, those are super important for any startups that have apps or do business through their websites. You do want to have very clear terms of use, setting forth not just commercial terms of transacting with your company for your customers, but also making sure you have all the legal protections for the company itself. And also privacy policy for every single website and an app you have to have as well. So director and officer insurance, indemnity agreements. This is something, indemnity agreement is something that I try to do for my clients as well to protect the founders for any future litigation down the road. Again, the assumption is we become successful, and then as you become successful, people start suing you. So you do want to make sure that you are protected to the fullest extent allowed by law. And then eventually when you get a lot of employees, a lot of advisors, a lot of investors, you do want to get director and officer insurance to make sure if there is a decision that someone wants to sue you for, you have insurance to back you up so that corporation or you individually don't have to incur any of these costs. Employment-related agreements, this can become huge too at seed stage, Series A stage. And those are mainly employment agreements, IP indentions, assignment agreement, as we discussed earlier. We also sign arbitration agreements with all employees to ensure that if there is an issue, we know that we're going to an arbitrator to resolve the problem. And then also sometimes we sign non-solicitation and non-compete agreements and some other covenants with our employees. And the reason for 4 agreements rather than just one comprehensive agreement is to provide short, concise documents that everyone can read and understand versus a long document with 20 pages that is hard to follow for attorneys, let alone for lay people. So that's the reason for 4 versus just one long agreement. Securities regulations becomes extremely important when you start raising funds. Remember, there is no friends and family rounds for Securities and Exchange Commission in the United States. Friends and family means you take money from your friends, your family, which is great. There's trust. That's easy from a business point of view. It's a great source of initial financing, seed financing, pre-seed financing. But from securities law point of view, there is no such thing. Every single investor you have duties towards, and you have to make certain disclosures, and you have to do some other things that we can discuss at a different time when we focus on fundraising issues. Non-disclosure agreements, you want to have these too. You don't want to, annoy people or badger people by asking them to sign NDA for every single conversation. But it can be a very useful tool when you discuss strategic partnerships, when you have to disclose a lot of confidential information about your business. Letters of intent, LOIs, those are extremely important too. This shows that the startup is gaining traction, that it's signing LOIs with strategic partners. So it's important from a legal point of view to kind of outline the main rules of the partnership, but at the same time, it's important from a business point of view as well to show this to your investors, potential investors, to look, we're making progress. We have this great partnership. It's going to help us to achieve certain milestones, but it's also going to show that you're working with people and some other people in your same industry, in your same space, are interested in your products or services. Customer agreements, and these are purchase orders, master services agreements, especially if you work B2B, right? You sign a letter of intent, and then you have to sign the actual agreement, and that's where the purchase orders and supply agreements and manufacturing agreements for hardware companies, and services agreements, master services agreements for more software-focused companies come into play. And last but not least, valuations. And valuations become important as you start raising funds, as you start issuing stock options to your employees and advisors. And there is a code section 409A in the Revenue Code, which is extremely central to valuation issues for any startups. And again, yesterday we did initiate, a few days ago, did initiate another 409A valuation for one of our clients. And the reason was that they were issuing stock options to 8 new employees and board members. And we wanted to make sure that we follow the tax rules of issuing equity incentives to board members and employees. Again, making sure that they will get all the tax benefits of this issuance. So this is everything I wanted to discuss. Thank you so much, and please go ahead and ask your questions if you have any.
Hayk, thank you very much. The presentation was super informative and covering all the important aspects. Thank you. So we have a couple of minutes actually for our questions and answers. And maybe we can start with the questions we have received earlier. By the way, there were some questions also related to topic out of today's scope, but don't worry, we will cover it in the upcoming webinars as well. So yeah. The first question is on intellectual property, specifically patents. How can a startup know whether its invention is new and different from anything that exists and is qualified to be patented?
Yeah, that's a good question. And by the way, not an IP attorney, not an intellectual property attorney. Especially for patents, you have to have an additional license, which I don't have. So patents is not something I myself do, but I do have people that work with us that help with patents. But the question that is being asked is not even a legal question. It's more a business or science question. And there are some consulting companies that we work with that we're more than happy to, make introductions to. But when you want to understand scientifically, if what you're doing is new, you have to speak with a consultant first. Or if you speak with an attorney, just ask them to make referrals to consultants they work with so you can do some due diligence or investigation of your invention and then see if this is something that's patentable. That's the term we use, patentable inventions, to begin with.
Okay, thank you very much.
Of course.
So the second question is, how can a business founder talk safely to an investor or business partner without an NDA, and if it's required for those talks and discussions in the first phases?
So yeah, good question. It's not required by law. It's not required by law. And sometimes it's not even recommended by attorneys, even attorneys, because attorneys are there to follow the formalities to make sure that, the client is protected. But sometimes business strategy or business goals, overshadow the legal needs. And even I myself sometimes tell my clients that, look, I know this person, or it's a major VC, there is no way they're going to steal your information and start a new company because they're not in that business. They're in business of investing in companies. So I do understand the need and the desire to protect that information, but it really depends on the actual fact. If someone just reaches out to you and tells you, oh, I want to talk to you, then of course you want to share an NDA with them because you don't know the person. But if you know someone personally, or if you know of someone who introduced you to that person and you trust that the person that made the introduction, and then the person trusts the investor, then it, again, can maybe seen as unnecessary to even share an NDA. But that being said, again, look at the actual facts and circumstances of each relationship. Just keep in mind that some people speak with 10 startups every day. If they had to sign 10 NDAs every day, it would be extremely difficult, if not impossible, for them to comply with all the requirements in each NDA, let alone, pay an attorney $1,000 every single time to review and revise an NDA before they sign it. So because of these technical and more substantive issues regarding signing NDAs before every single conversation, try to analyze the situation and act accordingly.
Okay, thank you very much. And as we are running out of time, I guess we can cover one more question, and that would be it for today. And can I ask you, please stop sharing just so people can see you?
Oh, of course.
Yeah, thank you.
Awesome.
And actually, the third question is again related to intellectual property. What is the direct consequences of not protecting anything for a startup, again, in intellectual property?
The simplest thing, right? We discussed inventions, assignments. At least sign those agreements. At least have an attorney draft a really good contract, intellectual property assignment or inventions assignment contract, along with a confidentiality clause in it, to ensure that when you speak with investors, for your own sake as well, of course, you want to make sure that your company owns all the IP that you pay for to your employees and advisors and contractors, but also it will definitely come up when you raise funds. When you raise funds and you have no inventions assignment agreement, that's going to be a huge problem. An investor is going to ask you, especially an investor that knows what they're doing, they're going to ask you to sign intellectual property assignment agreements with every single person you work with. Or if you don't work with a certain person, at least sign a release agreement with them, saying that they release all their claims and they, assign all the intellectual property they worked on and they may have created to the company. So that's the most basic one. You do want to make sure there are no challenges down the road. Someone saying, oh, by the way, I worked on this and I didn't sign any intellectual property assignment agreement, so now I own it rather than you. That's going to be a huge red flag for investors, or also for the company itself. It's going to be extremely hard to, cope with this distraction of fighting someone who's claiming that he or she owns the IP and then trying to grow the company at the same time.
Yeah.
And then also you want to register the patents and trademarks. And those are questions for IP attorneys, which I'm not, unfortunately.
Yeah. Thank you once again, Hayk. This was very, very interesting. And I think all of us have learned a lot. So to sum up, actually, if there are some unanswered questions that you have dropped in the comments, you can also email us. I think we can answer that as well. So that would be it for today. Thank you all for being with us, and thank you.
Yeah, thank you so much, everyone. I hope it was helpful. I hope I didn't confuse you even further about all these technical issues. But do feel free to reach out to me if you have any questions. I'll be happy to talk to you. Thank you so much.
Thank you very much.
Bye-bye.
And startup founders, if you have any issues or I don't know, some topics that you would like to discuss in the upcoming webinars, again, don't hesitate to text us, to send us emails. We will consider it in the upcoming sessions.
Yeah, we did have a few funding related questions. We'll probably have another session on funding, pre-seed and seed stages. So sorry for not addressing those questions today, but we'll do that very soon.
Yeah, I think they will be very interested because there were so many questions on that, and we will for sure cover it in future.
Thank you. Bye-bye.
Thank you. Goodbye.